Before we begin, I thought I would talk for a minute about the statutory amendments briefly. If you're in this room, you probably know in 2011, the Illinois legislature amended the Illinois Workers' Compensation Act, and among the some of the highlights from those 2011 amendments included carpal tunnel cases. Right now they're at 15%, unless there's clear and convincing evidence of 30%, but for the most part what we've seen is that they don't exceed that amount, the 15%. That is obviously a favorable development. It also went down from 205 weeks to 190 weeks. So CTS cases, carpal tunnel cases, that was one of the changes in the 2011 amendments, and that has led to a decrease in the value of carpal tunnel cases in general, I think. The fee schedule was decreased by 30%. Wage differential awards were limited to age 67 or 5 years after the award became final. One of the changes from the 2011 amendments had to do with arbitrators. Before, if you were injured in the Belleville or Collinsville area, your case would be assigned to that area. You'd be on the Collinsville docket. Now, when an application for adjustment of claim is filed, it's assigned to an arbitrator. So I guess that's good and bad, but we're in the southern zone, which is in Mount Vernon, Heron, and the Collinsville. So now, if you have a case, let's say, assigned to arbitrator Lindsay, and it happened, let's say, in Collinsville, the person can file a 19B petition. That case may be tried in Heron, Illinois, which is about 100 miles away. So it had to do with some of the changes in 2011. The arbitrators are only supposed to be here for a certain period of time before they're moved out. There was a concern, I think, after you probably read some of the newspaper articles from that time period. There was a concern about arbitrators staying in a position 15, 20 years. And so this was one of the changes. And again, I think the only downside really is now you've got a case that happened in Collinsville. You may be trying this down in Heron. And of course, it's kind of the luck of the draw which arbitrator you get. You may get, some of them are more conservative than others. It really is, you don't really get a choice on that. So that was one of the bigger changes now. One of the things they didn't change, we'll get to the cases here in a second, but the last thing, one of the things they didn't change was causation. Missouri, as you probably know, has the prevailing factor as the causation standard. Unfortunately, they didn't address that. And it is still a cause, a contributing cause. Could it have aggravated? All those make it compensable, which very low standard of causation. Hopefully the next time they address these issues, that will be something that will be addressed because the causation standard is still ridiculously low.
I know it's, with Governor Rauner coming into Illinois, I know he's made it a priority to address workers' compensation costs, and he has talked about looking at changing the causation standard. Given that he's a Republican governor with a Democratic-controlled House and Senate, and the legislature hasn't changed from the way it was, I don't know how much traction that's going to get. I don't know how much faith to put in that, but it is something that's being talked about and is being brought up.
And one other thing, and Mike mentioned this to me last week, just to go back to those carpal tunnel cases for a minute, you had a pro se, didn't you, before one of the arbitrators where it was settled for 13% or something like that? Is that a carpal tunnel case?
Yes.
Why don't you tell them what the arbitrator said with regard to that settlement?
It's a story from Mr. Hendershot. He told me yesterday. The carpal tunnel case had been settled for 13% of each wrist, and I wasn't there, Bob was, but from my understanding, arbitrator Lindsay told the petitioner, well, it's possible if you'd taken this to trial, you would have gotten less, 12 and a half, maybe less. I think you're seeing the value start to come down a little bit, and I think that's going to be borne out in some of the cases we're going to talk about today.
And Mike has prepared these materials. Why don't you describe how these are organized, how you're organizing these cases?
I I've drafted the case law update for a few years now. I tend to follow the same approach that I've done in the past. The first couple cases will address accident arising out of and in the course of. There's one case that will address medical benefits. One of the big things that I saw in the cases, looking over them for the last year, was temporary total disability, the aftermath of interstate scaffolding and how the arbitrators and the judges are addressing TTD. So there's a bit of a focus on that. A new focus for me in writing this was, in the past we hadn't seen a lot of cases addressing the 5 factors and the ratings. Now you're starting to see that. It's been in place for a while. People are getting them. So there's a number of cases in there addressing that issue too. There's a couple cases addressing permanent disability benefits, wage differentials versus permanent total disability. And I was advised many years ago when I started doing this to always include a fun case or a funny one. And the last one deals with improper conduct by employees, and that's what that case is designed to do. Going into the cases first, the first one in the case law update is Pryor v. the Illinois v. Casson Transport. And this case dealt with a traveling employee. Pryor was a truck driver. What he did was if he knew he was going to be on the road overnight, he'd pack an overnight bag, and then he would drive from his house to the terminal. And that's when he would start loading up the truck, and that he would drive from the terminal and return to the terminal at night or when he got back from his trip, and then drive home. On one morning, he woke up, got his overnight bag together and took it out to the car, and as he was bending over to put it in the trunk, he threw out his back. And he filed a claim claiming, well, I'm a traveling employee, I'm in the course of my employment, this is a compensable injury. The arbitrator concluded that the overnight bag and lifting it was not sufficient enough to put him in his course of employment. And when he appealed to the commission also hit on this, noting he hadn't left his home at the time of the accident, and the risk of injury at that point was still a personal risk. It wasn't sufficiently connected with the employment in order to be a risk peculiar to his work. His travel for work had not yet begun. He appealed all the way up to the appellate court, and the appellate court affirmed what the commission and the arbitrator did. They said, even assuming petitioner had left home at the time of his injury, which he hadn't, he was preparing his regular commute to the terminal. Essentially, the Court of Appeals found that he was simply a commuter. He was not a traveling employee yet because he wasn't doing anything abnormal to what he would typically do. It wasn't a continuous trip. He wasn't stopping off at the terminal to go someplace else to do work. And for that reason, because it occurred during the regular commute, the traveling exception, or the traveling employee exception, did not apply, and the commission was right to deny petitioner benefits. The next one is Young.
This is the Young case. Had to do with a gentleman who was an inspector, and he would parts would come in, he would take a look at them, and he'd move them on. But one of the things he had to do is he'd have to reach into a box, and it was, as described here, 16 by 16 inch box, 3 feet deep, to retrieve a spring clip. The arbitrator and commission looked at this and said, this is a neutral risk. They analyzed it under, there's 3 risks: personal risk, neutral risk, or employment-related risk. And the commission felt that it was a mere act of reaching down for an item, did not a risk beyond what he would do in his normal daily activity. They appealed that to the commission. And just as one more thing before I get to the appellate court, the story seemed to get, it was kind of like a fish story. It would get, every time you reached into the box would get deeper and bigger and heavier. So, he kept saying, now it's, you reached way into the box and did this. So I think the commission just didn't believe this guy and said the story changed a little bit to some of these doctors. So I don't think they believed them, but they also felt it wasn't a risk incidental to the employment. The appellate court disagreed, and the appellate court said that it was an improper analysis of the case, and as it says up here, they improperly examined his accident as a neutral risk as opposed to a risk associated with his employment. The reaching into the box was an employment-related risk, not a neutral risk. So there you have the arbitrator and commission saying this simple act of reaching into a box is not compensable. The appellate court, unfortunately, disagreeing and finding the case compensable.
And one of the things that I pulled away from Young, and including it here, was it kind of showed the trend we're seeing with the appellate court. In Young, the arbitrator denied benefits, the commission had affirmed the denial, the circuit court had confirmed it, and this was a manifest weight case, and yet the appellate court reversed and put in benefits. We're kind of seeing that trend now with appellate court cases. They're being more willing to overturn manifest weight if it works out in the petitioner's favor, as opposed to ours. I've had a couple cases like that, and we've seen some of the cases like that, where you're seeing the commission and the arbitrators become slightly more conservative. The pendulum is swinging back at the appellate court, which you could always trust to be more conservative and more knowledgeable about workers' compensation, but now the pendulum is swinging towards liberality on that side.
And just to add to what you're saying, I mean, you probably all know this, but as opposed to Missouri, Illinois has its own separate workers' compensation division, workers' compensation appellate court, which specializes in those cases. Missouri does not have that.
Going into Butler, I thought this one was interesting because I think you're going to start seeing a little bit more of this kind of thing. Butler was a teacher, and she also coordinated technology for her school district. And she testified she had 2 minutes to get from Class A to Class B. And while she was going between these two classes, she learned that the computers were about to be re-imaged. And since she was in charge of technology, she wanted to let everybody on the technology team know, hey, you've got to back up these computers before they're re-imaged. She was walking, she was going downstairs, and she was texting. Wasn't looking where she was going. She acknowledged that she probably shouldn't have even been doing it. The arbitrator denied benefits, concluding petitioner did not show she was at a greater risk of injury because of her employment, and noted she had placed herself at a greater risk by texting while descending stairs. The arbitrator also found significant the fact petitioner had not been ordered to send the message at the time, even if it was work-related. The commission, however, reversed. The commission stressed, first off, that contributory negligence on the part of the claimant is not a defense in a workers' compensation case. Just because she knew she shouldn't be texting while walking downstairs, that doesn't mean that she can be denied benefits. Further, the commission felt the accident was work-related because she was sending a work-related text of significant importance, which she thought was urgent in nature. It didn't matter whether the fact that the message was urgent was a reasonable belief that she held. What was relevant was that the petitioner herself believed the work-related text was urgent. And that's what made it a compensable injury according to the commission.
The next case is Taylor versus Caterpillar. This is one of these cases that has to do with, usually we talk about PTD or PPD. This has to do with medical benefits. And an interesting case, I refer to it as the sleep number bed case. But you look at it, and I guess the takeaway is, when you're presented with a situation, you don't necessarily accept that when they make an outrageous request like this, that you have to accept it. In this particular case, this is a 33-year-old guy, pretty young guy, and he ended up having 4 back surgeries, a lot of treatment. He goes on the internet and says, I need a sleep number bed. And somehow he convinces the treating doctor to go ahead and write a prescription for that. On cross-examination, the doctor says, yeah, I usually don't prescribe those, and I don't know if there's any medical necessity for it, but yeah, sure, we'll do a sleep number then. The respondent reasonably gets a UR to say that's not indicated, as indicated on the screen here, the official disability guidelines. No studies supporting the purchase of those things. So it goes before arbitrator Lindsay. She denied those benefits for the sleep number, but she said it wasn't medically necessary or reasonable. You can see her points here. The doctor didn't typically do this. There was no proof that the sleep number bed, which she picked out rather than her position, would provide any medical benefit. And he, of course, went for the top of the line. And, of course, and she said that's not. So it was just an unreasonable request. The employer fought it, and they won before arbitrator Lindsay. So, interesting case.
Now we're going to talk about temporary total disability benefits. And as I said earlier, this was, in my review, this seemed to be one of the big focuses in the cases over the last year, and especially dealing with the aftermath of interstate scaffolding, two words that I think you're going to hear a lot in the next few minutes as we go through these cases. The first one is Matusik, and if it sounds familiar to you, it should. This case had popped up before when the commission had affirmed the arbitrator's finding denying TTD benefits. What Matusik did was he was a night stalker and he kept stealing cigarettes.
A what?
A night stalker at the STOC.
Oh, I thought you said.
I know. Anyway, he kept stealing cigarettes from the employer, and what the respondent's attorney did at the trial was get Matusik to testify. Yes, I knew that stealing cigarettes could result in my termination, and therefore I would be out of a job. And they essentially argued, well, he knew that he would get terminated by stealing cigarettes. This was a constructive refusal to do his light duty work. This went up, and that had been affirmed by the circuit court, but the appellate court reversed it and reinstated Matusik's TTD benefits. The appellate court relied on interstate scaffolding, citing the employee's TTD obligation continues until the medical condition has stabilized. The appellate court found that in interstate scaffolding, the Supreme Court had rejected an interpretation of the act that would support a denial of TTD where the employee's vocational conduct was the basis for termination. The appellate court felt the commission had erred because they considered petitioner's conduct with reference and reliance on his termination from employment. And even though Matusik testified he knew his voluntary conduct could result in his termination, it was not sufficient to support the commission's denial of TTD. The court held the Supreme Court in interstate scaffolding specifically considered and rejected an analysis which included an inquiry into whether the employee has engaged in misconduct constituting a constructive refusal to perform the work. Essentially now, if you take this case, it doesn't matter what the injured worker does when he's on light duty. If he can't work, or he's not at MMI, and you don't have work that can accommodate the restrictions, you have to pay TTD. They're taking this to its logical conclusion. There's almost no basis upon which you can terminate TTD other than if he actually refuses to perform light duty work.
More bad news on the TTD front. This is the flower shop case. This lady hurt herself as a nurse when she was receiving TTD, but in 2007 she had opened a flower shop and she owned it and her daughters ran it. But while she was on TTD, she would go in there 3 days a week and do various activities, and they had some video taken, and among the things that she was doing, I'm reading here, was carrying bags, sitting on the back stick of the business, walking around the shop, picking wildflowers. And she admitted that she answered the phone, picked up faxes, grabbed flowers for her daughters. Sounds like working, but apparently it is not. well, to follow up on what Mike said, the key phrase is had it stabilized, and they did not feel that this work that the person did at the flower shop constituted that. They said the petitioner received no income from the shop, does no more than the shop, does no more at the shop than she would do at home, and said the proper inquiry was whether the petitioner's work was evidence of whether her condition stabilized. It did not, and again, to follow up on what Mike said, the inquiry is whether it stabilized. Or doing these activities at the flower shop didn't constitute that.
Then there's Rosales. Rosales was a permanent resident of the U.S. since 1994, but at the time she was hired by the employer, her green card had expired. She had notified the respondent of the situation and testified once a month she would show her supervisor documentation her green card was being renewed. She was allowed to continue working for the employer for 1 year despite not having a green card. But in the interim, as all this is going on, she suffered an injury in her hand, and she was working light duty. And eventually, after about a year of petitioner continually showing her supervisor the work that she's trying to do to get this green card, and after the respondent got an IME, the petitioner was fired for failing to resolve her immigration issues. And the question was whether or not she was entitled to TTD benefits at that point. Again, the commission looked at interstate scaffolding and said the only issue when determining if TTD benefits are due a claimant is whether the employee remains temporarily totally disabled due to the work injury and whether the employee is capable of returning to the workforce. Neither petitioner's immigration status nor her termination had any effect on the analysis of whether TTD was owed. You could argue she didn't have a green card, nobody else is going to hire her. That didn't matter. The only inquiry on a case on whether or not TTD benefits are owing is whether they remain TTD by a doctor's note due to the work injury and whether they were capable of returning to the workforce physically.
The next case is Macadon, and this one, it's a slight twist on it, but the person had an injury and had restrictions. So the job ends at the end of the year, 12/31/12. And even with the restrictions, the person could do the full duties. The arbitrator, though, said no full duty, the person's entitled to TTD and penalties for stopping it. But the commission disagreed a little bit and said found that the petitioner was capable of performing this full duty, and they modified the TTD award. They distinguished interstate scaffolding by saying, as you can see on the screen, the petitioner was capable of performing his full duty work and admitted he was capable of his full duty work. They modified the award of TTD benefits from the arbitrator. They they kept the penalties, so the penalties they stayed in effect. On that one.
Now we'll try to get you some good news, now that we've bummed you out over TTD benefits. We're looking at permanent partial disability benefits, and this is analysis under the 5 factors that were put in place with the amendments in 2011. The first case that we're going to look at is Booten. And Booten had a partial lateral meniscectomy. He returned to work without restrictions, and he had some complaints, but he underwent a series of injections. The case was tried before Arbitrator Granada. Arbitrator Granada went through the 5 factors. He noted there was no rating from the respondent. He continued to work as a highway maintainer following the injury. He was 49, so he's a little older, but he has many future years to work in his occupation. He did not demonstrate any loss of earning capacity, and he demonstrated evidence of disability via the medical records. Arbitrator Granada awarded 20% of the right leg. The commission reduced it, and reduced it from 20% to 12.5% on an operated knee. The commission looked at the following factors within those 5 factors. They noted following the surgery, he failed to report any major issues. He did not testify he continuously struggles with his job duties or is otherwise limited, and he was able to perform his job duties just as well as he did before the accident. And in the Commission's mind, those factors were enough to drop at 7.5% of the leg.
I think Mike worked it out this way, that you would have the good case and then I would get the bad case. But they did the opposite in this one, and they increased it from 10 to 15%. This guy was on a SWAT member, a volunteer SWAT member, but the arbitrator looked at the 5 factors and said there was 10% PPD body as a whole. Well, the Commission increased it to 15%. One of the things they said was impairment does not equal disability, and impairment ratings have limited use. They said they found it highly relevant. I found this statement interesting. His shoulder has not inhibited his ability to do his job, so he can still do his job. But it's a weak point, and it keeps it in mind when he enters an altercation. So he can still do it, but he's worried about it, so it was increased to 15%.
I didn't take all the good ones. On Bandy, nothing changed. But on Bandy, it was unclear whether or not Bandy had suffered a TFCC tear in his hand with his injury. And when Dr. Williams rated him, he provided 2 ratings. He did 1 assuming there was no TFCC tear, at which he would rate 2% impairment, and 1 assuming that there was a TFCC tear, and at that point he would provide a rating of 9%. Arbitrator Granado looked at the factors again, and he noted the ratings and noted petitioner's age of 46 years. The petitioner had undergone a job change, but she testified that it was voluntary. She had chosen to do it. It didn't have anything to do with her injury, and acknowledged Dr. Braun had released her to perform her old job at full duty. They also looked at her, whether or not her wages had changed, and they had, again, because she had voluntarily changed her jobs, which the arbitrator had noted, but now she no longer had weekend work or overtime. And finally, they looked at the operative report, Dr. Williams' testimony, and his records. And based on all that, arbitrator Granado awarded 20% of the hand. Even though the ratings were 2% or 9%, you're still seeing an award for 20%. I don't know that the rating really was the defining factor in this case. I think more what they were looking at here was her ongoing complaints within her hand. And despite the fact that her job change was voluntary, she still took one, and I think that's something arbitrator Granado took into consideration in issuing this award.
There follows another case, impairment rating, and this person had fusion surgery, cervical fusion surgery, C5-6, C6-7, but the arbitrator felt the person had a very good result, and this was arbitrator Lindsay. She looked at the 5 factors again. There was a impairment rating of 10% body as a whole, and she gave it, she gave an award of 17.5% body as a whole for this fusion surgery, which, which is a very good result. I mean, that's a good award. But considering, as Mike has discussed, considering the fact that we now have these impairment ratings, it seems reasonable. The commission looked at it and didn't necessarily disagree with the fact the person had a good result, but said they think there was more disability than was awarded. And the phrase they used, which I thought was interesting, was they increased it, by the way, to 22.5% of bodies going from the 17.5%. And they said it's less than is traditionally awarded. And so, based on prior cases, they decided to increase it to 22.5%.
I did take some of the good cases, though. This is bone.
Well, that just goes to show, I guess what I'm trying to say, you had this amendment to the statute, and the impairment ratings are put in there, and then the commission comes back and says, well, you know, she did the analysis pursuant to looking at the 5 factors in the impairment rating, but traditionally these cases go for more, so we're going to increase the reward to 20%.
And in bone, this was a foot and ankle injury. We had a rating from Dr. Kraus. This was tried before arbitrator Gallagher. Some of you may have some familiarity with him. Arbitrator Gallagher noted the impairment rating. He noted the likelihood the petitioner would continue to experience ongoing symptoms with his job duty of pushing heavy carts. He noted the petitioner's age of 39 years, which to arbitrator Gallagher meant the petitioner would have to live with the effects of the injury for a significant period of time. There was no evidence on the effect of injury on petitioner's future earning capacity. And one of the things I noted here is that very rarely are you seeing petitioners present any evidence of impact on future earning capacity. I don't know how much petitioners' attorneys are looking at that or trying to put together evidence on it, but I didn't see it in any of these cases. None of the arbitrators really found that. And then arbitrator Gallagher noted the medical records and noted all of Bone's ongoing complaints. He then awarded 30% of the foot. The commission reduced it by half and cut arbitrator Gallagher's award to 15 of the foot. The commission focused on the fact Bone was performing the same job duties as he did prior to the accident. He was actually earning 50 cents more per hour than he had prior to the accident. They also focused on Dr. Kraus's examination, noting satisfactory alignment and everything else Dr. Kraus found in the performance of his examination. And that was their basis for lowering it from 30% to 15%. So I think that you are seeing some impact from getting disability ratings from the doctors, but a lot of it seems to depend on what the arbitrator awarded and which arbitrator it was more than anything you're seeing in the actual records.
We're going to talk briefly about permanent partial disability benefits and wage differential. Where there's a recent case that came out, Lenhart was the name of it, and interesting case, but he had a back injury, a lot of treatment, and it was a nature and extent case. He says he was permanently disabled, but that was denied. He did not receive a permanent total disability. So you can see on the screen, it was, excuse me, the arbitrator initially found he was permanent total. The commission reversed it. And what was interesting though about this case, not so much that, but was that the commission made an award at that point of 75% of the body as a whole. And it's appealed to the appellate court, and the appellate court said the commission erred in failing to determine whether the petitioner was entitled to a wage differential. It was remanded back to that. One of the things I found interesting was the court said the commission erred, as I said, in failing to determine about a wage differential. They noted the respondent had stipulated petitioner could no longer meet the demands of his customary work. They noted the Section 12 examination found he could only do light duty work, and there was a voc expert. So they said there was evidence in that. So they remanded it to the commission. So interesting case though, where the commission says no PTD. Here's an award of permanent partial to 75%. The appellate court says you have to consider the possibility of wage differential.
And then there's the Village of Deerfield. This one was an interesting one because it drew in the Will County decision that decided the shoulder was no longer part of the arm, but was in fact part of the body as a whole. In Deerfield, what happened was the petitioner had 3 separate injuries. He had injured his left shoulder in one accident, his cervical and lumbar spines in another, and it aggravated his left shoulder in a third. The arbitrator, the cases were consolidated for a hearing, but the petitioner had requested separate decisions for each case. And the arbitrator awarded permanent partial disability in the first accident, wage differential benefits for the second, and then denied on the third for causation. The respondent appealed it to the commission, it looks like just to get an appeal done. But what the commission then did was, after Will County came out, they consolidated the permanent partial disability awards from the first injury to a single award of 18.8% to the body as a whole, pursuant to Will County. What the respondent then did on appeal was argue, well, the cases were consolidated for trial, you cannot get permanent partial disability and a wage differential for the same body part in a consolidated hearing. And the appellate court looked at that. They focused on the decisions that had gone before, but they distinguished the two injuries, saying, yeah, while the shoulder award was a body as a whole award, and a wage differential is in the same section as a body as a whole award, we can do this here because the shoulder and the neck, while both awarded on the body as a whole, are distinct body parts. They said they were not the same body part. And they cited the fact that in Section 8, when it talks about the body as a whole, there are specific limits or awards for various body parts related to the head, the teeth, the hearing, stuff like that. And they said if the Act had intended for everything awarded on the body to be constituted as the same body part, they wouldn't have done that. I don't know how far you can believe that or not, but my takeaway from this is the appellate court went out of their way to make sure he could get both permanent partial disability and a wage differential award. They went out of their way to make sure that the petitioner got benefits in this case. And again, that goes back to what I was saying earlier. I think you're seeing that in the appellate court decisions. They're going out of their way to try to make sure injured workers are getting benefits when maybe they're not actually entitled to them.
This is the fun one.
This is my funny one.
Well, this guy is just a lunatic. I mean, I don't know how else to say it. He's a, he goes outside his office and he, to calm down someone who had been arguing, and he locks himself out of the office. So his solution to that is to go to the stairway, get a chair, reach up, move some of those ceiling tiles out of the way, climb over the wall, and be like Spider-Man and leap down 8 feet, except he wasn't, and he injured himself. He suffered a calcaneal fracture. The respondent, the employer, also got some evidence from an investigator saying that how he said it happened couldn't have happened. I guess surprisingly, maybe not surprisingly, the arbitrator found those actions were for the benefit of the respondent and awarded benefits. But the commission overturned it, saying it was a very dangerous activity and did not arise out of employment. So you have a situation like that where someone just does something so crazy. Definitely take a look at it. It's just really a defensive case. Do you have any questions? That's really the end of the case.
On the, you kind of briefly went over the law changes, and I know I'm a day late, and I'll start with this question, but on the carpal tunnel and the changes to the cap, that was intended solely for occupational disease, repetitive motion,
Yes.
right?
Right, just repetitive traumas.
Okay. Do you think it has any bearing on, I don't want to say traumatic, I'm trying to remember exactly what mine was, but another part of the body, and then they also did the carpal tunnel surgery as a result of, sometimes you'll have something like a cubital tunnel, and then you end up, you kind of start up here, you kind of go down. Any
Well, I mean, it's limited, and you can jump in on that too, but it's limited to repetitive trauma cases. So I think there's a question. You're right. I mean, if it's a traumatic incident where someone maybe fractures and develops CTS after that, I think it's It may not be, you know.
I think they should get less personally.
Yeah. But it's limited right now to the repetitive trauma cases. I think it came out of that whole, you know, Menard prison in southern Illinois with, you know, the locking of the gates and just
Yeah.
so many claims that developed. And they said, wait a minute, we got to make some reforms here. And they said for these repetitive trauma CTS cases, they're going to say 190 weeks, we're going to limit it to 15%. It's been beneficial.
Yeah, I agree. I don't think it would apply in an acute carpal tunnel case. I had one where a guy got acute carpal tunnel from putting himself, like he was on fire and he got acute carpal tunnel from trying to put himself out of fire. And I don't think the caps would have applied in that situation. I think he still would have been entitled to 205 weeks, and the 15% cap probably wouldn't have applied. Anything else? We didn't mean to make everybody dejected and sad. That wasn't the point of the case law update.
We know we're the last one of the day, so
Yeah.
hold you up and just any other questions?